juvenile cases do usually begin with allegations coming from a law enforcement agency like a police department, whether it's local or whether it's the state police. However, those charges do not go directly to a district attorney's office as they would do for adults. They actually go to a juvenile court office first. The juvenile court office has personnel that are trained to handle these criminal cases. They actually assist with the intake and evaluation at a very early stage, and they're responsible for bringing the allegations to the district attorney's office and ultimately to the judge that handles the juvenile court in the first instance. For the young person who is involved in the system, it can be quite frightening because the very first interaction can result in their actually being removed from their family. If the crime is serious enough, the juvenile court office will make the determination in the first instance to actually place a young person in detention. In other words, remove them from their home and place that young person in a facility. Within 72 hours, the juvenile court office, in concert with the district attorney's office, then has to go before the court and make its case for why this young person needs to be removed from the home. It is a high burden to meet because the juvenile justice system is supposed to be informed by the notion that the least restrictive intervention is always the most appropriate. However, when you do have a situation where there's been some kind of violent assault, something involving a firearm, really any kind of deadly weapon, those kinds of cases are generally going to result in a placement outside of the home until there is a resolution of the charges. Normally, courts are fairly easily persuaded that a young person who is involved in that kind of behavior represents a threat to the community and isn't being under appropriate control within the home. As far as the actual resolution of charges, it really is very similar to the adult system. That part of it is. There's a burden on the Commonwealth, on the district attorney's office, to prove each element of the alleged crime beyond a reasonable doubt. One significant difference is if you do have a hearing, there is no jury. Every case is held in front of a single judge, and that judge makes a decision as to whether the young person is guilty or not guilty, again making an assessment of whether the Commonwealth has proved its case beyond a reasonable doubt. The same rules of evidence, the same protections again apply for the young person. The young person is not required to take the stand to make any kind of defense on their own. It's at that point that the divergence from the adult system really comes in. In the adult system, we have grades of misdemeanors and felonies, and we have an offense gravity score for every single crime, and we have a prior record score. So there's almost a mathematical basis, an equation that a judge can put together for a recommended sentence, whether it's probationary or whether it's for incarceration, and the length of the incarceration. All of those things can really be determined mathematically. However, in the juvenile justice system, it really doesn't matter what crime has been, proven. Whether it's a felony, whether it's a misdemeanor, the disposition, which is the term we use in the juvenile justice system to describe the sentence, is really determined by what the specific needs of the child are. Of course, if there's some kind of restoration that needs to be made to a victim, that's always going to be part of the sentence. But this is not just a question of a young person serving time in some facility and watching the clock until their time is up. The goal here is to rehabilitate the young person, make them more productive citizens and less likely to commit the acts again. Put them in a position, and frankly, their families in a position where this kind of behavior isn't going to happen, and hopefully put the child on a path toward a more productive tomorrow. The challenge is that it's an inexact science. And part of our job here in this representation, just going beyond the vigorous defense of any allegation of crime, is at this stage, if we do get to it, is to help the court arrive at the most just decision, the most reasonable decision, and yes, the least restrictive that is possible. If we are in that situation where we need to prepare for a disposition hearing where the judge will decide and announce exactly what will be going on with the child going forward, we will help you obtain the right evaluations from mental health care professionals, substance counselors, any number of well-respected and professional people who will provide opinions to the court that will allow a fair disposition. We want to, again, do everything we can to move the child forward in that unfortunate situation. We can definitely assist with that. There have been highly publicized situations where some juvenile dispositions have resulted in very unpleasant experiences for parents and children. We're very cognizant of that history, and we're very much committed to preventing that happening to any of our clients. We're intensely involved at all stages of the process. And I would want to say also that not every case goes to a hearing and a disposition. We're often in a position to negotiate something where some very light supervision is appropriate. Again, there's an understanding that young people will do things that perhaps aren't great for our larger society, but locking them up is not any kind of solution either. It will just further traumatize the child. And I think the system is catching up to that notion. And we are certainly going to help at every stage for the system to produce that kind of outcome. So when we're working with any young person, we are definitely mindful of what the short-term future looks like. The next 6 months, year or year and a half, when there might be some supervision from the juvenile court. But from the moment the case comes to us, we're thinking about the more distant future, because a juvenile adjudication is just another word for conviction that applies in this system, can have far-reaching effects beyond the age of 18, beyond the age of 21, and into the future. It is a fact that in Pennsylvania, there are first-degree misdemeanors and felonies that will actually impact future sentencing if there are any adult crimes that are imposed. Going beyond that, the ability to get employment when you have a juvenile adjudication is impaired or can be impaired. There are a whole host of issues that we're very much aware of when we're negotiating through with the district attorney's office and the juvenile court office that inform our approach. We're thinking, again, not just of the immediate future, but the distant future. If the ability to enlist in the armed services, the ability to have a job where you might need to carry a gun, the ability to maintain public housing for your family, the ability to stay in your school or move to a new school if there's some kind of difficulty in staying in the school you're in, your ability to qualify for a loan, a federal loan for higher education. All of these things are in play for a simple juvenile adjudication. And the rules are a bit of a hodgepodge. It's not obvious. It's not all felonies. It's not all misdemeanors, but it's enumerated ones. So we have to be very careful, and we're very much on top of that. We want to give the young person what the judicial system promises. We hope that we can deliver. We hope that the system can deliver that, but we don't expect it. We want to do that and ensure that outcome for our client. We're very much committed to that. These are some of the most important cases that come through the office because their consequences extend decades from today. And in my role, it's one of the most fulfilling ones I can have.